This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about the fact that fraud is a crime that should never pay, and why fraud eliminates the right to no-fault benefits when the person seeking those benefits lies, and why the court therefore eliminated an attempt to defraud a no-fault placement facility. Aric Lynn Holloway II, plaintiff, appealed the stipulated order of dismissal in favor of defendant-appellee Citizens Insurance Company of the Midwest in a case entitled Aric Lynn Holloway versus Memberselect Insurance Company et al. In the Michigan Automobile Insurance Placement Facility. A decision of the Court of Appeals of Michigan on May 29, 2025, where the plaintiff attempted to convince the Court of Appeals to allow his fraud to succeed. In a case involving issues of insurance claims, alleged fraud, and the eligibility for personal injury protection benefits, no fault, the Court of Appeals affirmed the trial court, refusing to allow the fraud to succeed. The case arose from a car accident where the plaintiffs, Holloway and his friends, were rear-ended by another vehicle that fled the scene. Holloway sustained various injuries and underwent spinal surgery at Advanced Surgery Center, ASC, assigning his right to PIP benefits to ASC only for them to find that Holloway had committed fraud in seeking benefits. Holloway sought PIP benefits through Memberselect Insurance Company, which was issued to his parents, and also applied for benefits through the Michigan Assigned Claims Plan, or MACP. Holloway's application stated he lived with his girlfriend and daughter, indicating no vehicles were owned in the household. However, he later testified he lived with his parents at the time of the accident, and his application included false service dates for attendant care services, which raised suspicions of fraud. ASC intervened in the lawsuit to recover PIP benefits it provided to Holloway. Eventually, citizens moved for summary disposition, arguing that Holloway committed fraudulent acts by submitting false information in his claims. The court found that Holloway's claims were based on knowingly false statements, which included fabricated service dates and misrepresentation of his living situation. The court ruled that he was ineligible for PIP benefits due to fraud. The court concluded, however, that Holloway was an aggrieved party following the final order dismissing his claims, thereby allowing him to appeal. The court granted summary disposition in favor of Citizens Insurance, concluding that Holloway's actions constituted a fraudulent insurance act as defined under Michigan law. The trial court emphasized that the statements made in his application and affidavits were material to his claim, and he was aware at the time he made them that they were false. Holloway's assertions that discrepancies were innocent mistakes were rejected. The court found no genuine issue of material fact regarding his knowledge of the false information he submitted. And ultimately, the court dismissed Holloway's claims for PIP benefits based on the determination that he committed insurance fraud. When a person injured in a motor vehicle accident lacks insurance in Michigan, the No Fault Act sets forth an order of priority for insurers who may be liable for the payment of PIP benefits. The court held that a person commits a fraudulent insurance act when 1. The person presents or causes to be presented an oral or written statement, 2. The statement is part of or in support of a claim for no-fault benefits, and 3. The claim for benefits was submitted to the MAIPF. The person must have known that the statement contained false information and the statement concerned a fact or thing material to the claim. Viewing the evidentiary record in the light most favorable to the plaintiff, the Court of Appeal found no genuine issue of material fact that the plaintiff committed a fraudulent insurance act. The record indicates that plaintiff was aware that the attendant care and replacement services affidavits he submitted were incorrect. The court concluded that plaintiff failed to demonstrate the existence of a genuine issue of material fact and therefore granted the motion for summary disposition and affirmed it at the Court of Appeal. In my opinion, no-fault insurance was designed to help injured people and take the profit out of fraud because the limited awards for no-fault accidents. In this case, fraud was obvious. The plaintiff admitted he lied in his deposition, but claimed it was just a mistake, not an intent to deceive. The argument failed because the evidence established that he intentionally and incompetently committed fraud. Crime doesn't pay, and young Mr. Holloway will have to pay for his surgery out of his own funds. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,050 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on youtube.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.